Good evening, everybody, and welcome to the latest edition of True Crime with the Sarge. I'm your host, Joseph Jackalone, and with us today is former Attorney General for the state of Idaho, Dave Leroy. Dave, thanks for coming on tonight.
You're welcome, Sarge. Any show named Sarge is a good show for me. My dad was a career Army Air Corps man and lied about his age and got into World War One, served through World War Two, and made me his basic private when I was growing up to police the area and work in the yard. So I respect Sarges, and you have my respect.
I appreciate that. Thank you very much. So we're going to jump in with the time that we have today about this Bryan Kohberger plea deal. When you first heard about the plea deal, what was your first reaction to that? Because it was kind of caught a lot of us off guard.
Well, it was my impression that if there was one moment in time and one particular set of conditions that could, against all odds, save us all 3 months of trial, $10 million to the taxpayers of Latah County, untold millions to the taxpayers of the state of Idaho for 15 or 20 years of appeals. If there was one moment in time and one set of conditions, that actually occurred. And the reason it occurred, in my opinion, was that the defense was very aggressive all the way through in preparation and delay and creating appellate issues. And by the same token, the prosecution was uniquely effective in the police work that put all of this together and in beating back many of those defense challenges. And then finally, the judge at the last moment, immediately before this plea deal came about, decided that there was not enough evidence for the defense to argue and to present some contention that there was an alternative perpetrator. And the judge at the same time ruled that we're not going to look for another 2 or 3 months worth of delay. So that all focused on that particular weekend. And the defense made some initiatives. The prosecutor replied back, and the deal was done.
Yeah, no, I mean, for many of us, I was kind of caught off guard, though. I didn't think that was going to happen, especially when they put forth the individuals that they said were alternative suspects and everything else that went with it. And all of a sudden, next thing you know, I'm taking a plea.
Well, the defense ran out of time. They ran out of alternative arguments, and it was apparent to them then, though not so much to us, as it became apparent to us in Kohberger's conduct at both the plea hearing and the sentencing hearing, well, anyway, he was going to take the stand. So the party was over for the defense in a sense, and they faced a very well prepared, very experienced prosecution team, and they took an honorable way out. And frankly, as the defense attempts to do in every death penalty case, they achieved their primary objective.
Now, how does these plea deals, maybe not so much Kohberger, but any plea deal, how do these usually come about? Is it something that the suspect or the defendant says, this is what I want? Or does the defense say, hey, listen, this case is kind of airtight? How does that work?
Well, there's no cookie cutter because cases come in all shapes, flavors, and sizes, of course, as do defendants, as do defense lawyers and prosecutors. But generally speaking, the defense is more often than not inclined to offer to the prosecution an opportunity to resolve the case short of a trial, although it is a matter of standard practice. Prosecutors will put out, well, the prosecutors have really got two decision points. Number one, the charging decision. Some prosecutors' offices overcharge a case when they know that it's really a lesser charge or the facts are more akin to some lesser view of the case. Some prosecutors routinely overcharge to almost force a plea bargain initiative from the defense, but prosecutors will typically, after they charge, either put out a written offer or, in some condition of local practice, convey an offer to the defense, indicating that were you to plead guilty to count one, we'll dismiss count two, and we'll recommend the following to the judge, that sort of thing. So standard practice in most jurisdictions is the prosecutor will throw something out there, But the actual bargaining process usually is initiated by the defense. They either have some interest in either soliciting that kind of offer or improving that kind of offer. So it's depending on local practice, it could go either way, but generally the prosecution is kind of locked into a concept, and the defense really initiates the actual bargaining on the matter.
Have you ever seen a case like this where I guess social media, I mean, has played such a big role? I mean, even Judge Hippler was talking about basically like sounded like he was getting threatened, so to speak, and about what was going on about you better do this or better do that.
Well, the judge was referring to the fact that some of the people who are most closely involved, I think some of the victim families, have encouraged the communication directly to the judge and the judge's chambers about attempting to dissuade going forward without continuing to seek the death penalty. That indicated a fundamental misunderstanding of who controlled the decision making with regard to the death penalty. Had nothing to do with the judge, other than at an early point in the case when the prosecutor gives a signal that this will be pursued as a death penalty case. The judge has a very limited scope and a limited amount of time to discourage that. But once the prosecutor has decided it's a death penalty case, he continues to pursue that until he doesn't. And in this case, it was the prosecution team, nothing to do with the judge or his people in his chambers that made that decision. So the encouragement to call the judge's chambers was both counterproductive and a non-starter. The judge protested that a little bit in his initial remarks at the entry of plea hearing.
And so you think about all the different motions that the defense had put out, right? And this basically they got knocked off one by one. I guess that kind of leads the defense into a situation to tell their client, say, listen, this is where we're headed. That's a real unfortunate position to be in.
Yeah. Well, the defense in this case was very aggressive, very appropriate in terms of not only overturning every stone that they needed to look under, but actually engineering a few stones that nobody had thought of before. They were actually, in my opinion, kind of trying to set up a United States Supreme Court argument that there's a constitutional right not to be convicted by the DNA of your ancestors. An interesting approach to genetic genealogy, and they obviously would have argued about that for years had this case not gone another direction. But it was quite well done by the defense in terms of the series of motions, and occasionally even going backwards to renew a motion that had already been decided two or three times, sometimes by an earlier judge and sometimes by Judge Hippler.
Right. I was just wanted a quick shout out to Forrest Nelson. Thank you very much for those memberships, Forrest. I was a little bit concerned about some of the crime scene issues that I thought just from my own job about different things, but they really had a good case. They built a good case. They had the FBI involved. They worked as a team, so they had all these things in place. And I think why a lot of the public was upset, or maybe I'm not speaking for all the public, but many of them are upset because they felt that the case was so strong. Why go down the plea route?
Well, remember, the public was upset at several different junctures in this case. First and foremost, of course, the public in Moscow, Idaho, and the University of Idaho community, all of the parents who sent kids to the school thinking that they're safe in this nice rural environment, were very upset. Then the public became upset at the situation of a very small rural police department, Moscow, Idaho, Latah County, apparently for a period of 6 weeks, not giving, by virtue of any public statements or announcements, any deliberate process or progress that they were making yet behind the scenes with that team that you had mentioned, involving also the Idaho State Police, the Idaho Attorney General's Office, law enforcement officers from Pennsylvania, as well as the FBI, putting together a superbly engineered, modern scientific investigation that led nicely, succinctly, and compellingly to Kohberger. And so for 6 week period, the Moscow PD was a bunch of bumblers that couldn't do anything right, and they were upset about that. And then, of course, at various points in time, when the documentary came out or when the movie about the movie came out, people were concerned there. And then finally, the biggest set of ire, of course, was that substantial portion of the population and that subset of the victim families that were convinced that this needed to go forward as a death penalty case. That's very explicable, frankly. On the dreadful, horrible facts of these four murders, there are probably very few cases in the last 125 years that had facts that were more deserving of the death penalty, if any, than this particular case. It's a death penalty case on the facts. But the fact is, these days, that Kohberger got a different kind of death penalty rather than the one that I previously described that lingers for the next 15 or 20 years.
So if I don't describe this next thing right, maybe you can describe it for us. Could a proffer have been offered as part of the plea deal from the prosecution, saying pretty much, okay, we're going to give you this plea deal, but you have to say X, Y, and Z, like where's the weapon, what was your motive, anything like that? Could that have been part of the plea deal?
Sure. The prosecution doesn't have to accept a defense offer. The defense doesn't have to accept a prosecution offer. And all the time, they dicker back and forth about the details. So, yes, the prosecution could have held out for more detail. The defense could have insisted, as they did, that that not be a part of a plea that was basically a Cadillac, a die in the penitentiary plea that took out all of those time frames, that took out all those cost frames, that took out the uncertainty of one or more of the counts not being unanimously agreed to by a juror, or took out all of the uncertainties related to asking any group of 12 people to unanimously agree on a morally difficult situation like putting somebody to death. Each party could have traded back and forth a little bit more. But what happened here was when the defense indicated that they might be willing to do something, the prosecutor adamantly and insistently, in defense of his case, in defense of his community, in his own good judgment, and a very, in my way of thinking, explicable and justifiable process, said, if you are to plead guilty, Kohberger team, your client and your lawyers, you will have to plead to the maximum penalties, waiving all appeals, waiving all possibility of seeking a downward departure 50 years from now from the parole board, acknowledging death in all four of the cases, and even admitting a burglary, which we can fine you for and give you 10 additional years for. So if you want to plead guilty to 4 consecutive life terms and 10 years under those conditions, we'll consider your offer. Could there have been more that the prosecution demanded? Yes. Might that have broken down the deal? Yes. On the other hand, also, as the judge indicated, might we have gotten some tepid halfway thing from Kohberger, either in writing or orally at one of those hearings that was untruthful or utterly unsatisfying? Sure.
Now, the whole thing about the appeals, there is zero chance he can appeal this, or is it still open for it?
Well, in my opinion, there's a zero chance that he can successfully appeal anything under the conditions of these facts, the record that was made, and the specifics contained in this plea bargain. We defer to defendants who claim at any point in time when they're incarcerated or facing trial the right to pursue their constitutional rights. And so even if you waive all your appeals, as Kohberger did, you still have a narrow theoretical possibility of claiming that you had incompetent counsel or you were not voluntarily doing what you have said on the record you were voluntarily doing. And so we give to people the right to subsequently complain about decisions to waive their appeals in a very narrow scope, in a very unlikely situation, inapplicable to this case, I believe. Could he file an appeal? Yes. Would it be summarily dismissed? Yes, in my opinion.
Right. So this is because this is something I would, fear for the family, right? Because you make this deal, some of the family members weren't happy, and then all of a sudden he can turn around and pull a rabbit out of a hat. I think that would be really bad for the
Yeah.
families for sure.
Well, again, on these facts, as good a record as was made, the unique, aggressive, competent attorney team that he had advising him, the clarity with which these appeal waivers were made, it's a non-starter in my opinion, even though he's got a theoretical right, as the judge duly informed him.
And is there any risk of, let's just say, 20 or 30 years from now, Idaho law changes and they say, we're going to eliminate, like, I think some of this happened in California where they took all the death penalty people and they put them with life without parole. And the next thing you know, people are getting paroled who should have never been paroled.
Well, generally speaking, Idaho tends to go whatever direction California is not. And you may recall that we recently decided that because of the arguments made by defense counsel, because of the difficulty and expense of acquiring death infusion chemicals, we're going to fall back on the firing squad. So, sure, can laws change? Mostly those affect procedures over time. In other words, you might, as a sex offender, have the right to seek a cleansing of your record when you're convicted, but in recent years, the legislature has taken away some procedural right to do that. So you can lose rights more readily than you can gain rights in a criminal justice system, especially in Idaho.
Right. So that's something, I guess, I know Idaho is not California. We know that. And it's not Florida for sure. But, there's always something we concern where you say to yourself,
Yeah.
like the electorate changes.
Well, let me say, Sarge, in this case, in the Vallow case, in the Daybell case, these notorious cases that we've had here recently, I think the Idaho justice system has acquitted itself superbly. We've gone out of our way to insist that these defendants have full flower of constitutional rights, have very competent counsel, either public appointed or of their own choosing. We've had judges who've been overtly fair. We've had juries that we were able to seat despite overwhelming publicity that appeared to be honest, objective, and give the defense the benefit of the presumption of reasonable doubt. I think Idaho justice has served pretty well as a national model, an international model, in fact, because people were talking about this case to us when we were in Paris here in April. So, all things being equal, these cases do test and try a justice system. I was speaking in a judge's chambers only this morning and asked the rhetorical question, how do these kinds of notorious cases impact the day-to-day operations in the courthouse? And the judge ticked off a whole list of things that get bumped back, get de-escalated, get confused, security all over the building, that sort of thing. But in these cases, I'm very proud of what Idaho's done and how we've projected them. And we've had enough. Let's keep peaceful and law-abiding in Idaho, please.
I'm sure Idaho would like a break from all these cases, right? I mean, that's another reason why the plea deal. I mean, I was for the plea deal. I thought it was a good deal in that respect that you don't have to put the families through this long trial and everything else that goes along with it.
Listen,
Um,
our prosecutor had been in that office 33 years. He is the senior elected county prosecutor in the state. His shoulders are broad, his experience is deep, and to support the decision he made is absolutely justifiable, explicable in terms of the community, and frankly, in my opinion, and with a mere 53 years at the law, both as a prosecutor and a defense lawyer, starting that defense career, interestingly enough, in New York City. In my opinion, even the victim families who continued to feel strongly that this was and needed to be a death penalty case will be realizing, even perhaps as early as right now, some comfort from the contrarian position that indeed closure and certainty and a different kind of death in the penitentiary, can be equal to or at least almost as good as this 20 years of appeals that we would have otherwise faced if all of the contingencies came home.
Yeah, I mean, he's not going to a hotel, that's for sure. He's not going to a resort. He's going to what they define as one of the worst prisons in Idaho. So I don't know if
Well,
that's true or not, but no prison is good. I tell people there's no such thing as the worst. They're all bad. I mean, it's
yeah,
prison.
our maximum security institution is a serious facility. The Idaho State Penitentiary is a general purpose correctional facility with all kinds of layers of opportunity, classes, wire, security, and subsets, different campuses, etc. But maximum security is a serious deal. It's where the death inmates are. It's where people are locked up 23 hours a day. It's where isolation is the rule, not the exception. And in my opinion, I think the director of correction will likely be inclined for, I can say, the rest of Kohberger's life to keep him in that maximum security facility rather than ever introduce him into the general population for two reasons. Number one, it's consistent with his sentence and the horrible facts of what he did to this community. And secondly, for his own safety and protection, I think that isolation is probably necessary. Uh, Anybody in any other access may be looking to enhance their own standing inside the penitentiary facility by doing him some harm if they have access to him. We try to avoid all those incidents, but of course, that's a fact of prison life anywhere.
Sure, especially when you have people who have nothing to lose. I mean, you're already locked down in the cell 23 hours a day, like you said. Some of these people are never getting out anyway. So what's the difference? I
Yeah.
mean, that's something that's always a concern. I have a question from the audience here. It says, would Kohberger be allowed to further his criminal justice studies? Can he get his PhD? And is he going to be going back to school?
Well, yeah, whether he wants to be a serious academician or a perfect criminal, serial killer, he obviously flunked the final, and so perhaps he does need some additional tutorials. Yes, in terms of the things that he does have some potential access to, and again, subject to the director of corrections determination of how he fits into the community. But generally speaking, those inmates in the Idaho State Penitentiary maximum facility do have access to television entertainment, and they do have access under controlled conditions to a computer. So I presume that he can consider some kind of application to studies of some type, whether that's a PhD program. I would be unaware. On the other hand, I'm not sure that there's a PhD program in the country that would be very interested in having their name associated with a degree on his wall, even though only he could see it. But I do think it's important to remember that Judge Hippler, in his suggestion that one of the things we ought to be doing now that this case is concluded is to memorialize the victims and de-emphasize the interest that we all have in wondering why and asking him for more and looking for additional insights from Kohberger himself. The judge said that removes the agency from him. It makes him less important. It diminishes him. I think that's important. But in so saying, the judge also said that he did invite and encourage criminal behaviorists to study Kohberger so that we might, from a more legitimate and authoritative position than he probably himself would offer, try to understand what happened here and how he became so aberrant for the purpose not of playing games with him, but for the purpose of predicting these kind of outcomes and perhaps preventing these kind of outcomes from some other human being in our society.
Yeah, I mean, it was funny when you said something before because someone had asked me. He says, you've been teaching criminal justice all these years. Are you afraid of creating better criminals? And I'm like, well, he's the guy wearing the orange jumpsuit, so maybe you should ask him. I mean, but this is a fact of life. I said we don't do that for any other. I mean, any other job. I mean, we teach people how to become stockbrokers, and then they get arrested. Or you get a guy like Bernie Madoff. Do we stop teaching people because you have one or two people that do stuff? The answer to
Yeah.
that's no, but it's just part of the whole thing. I know we have a few minutes left, so I just want to ask you another question. The leaks. Do you think we're going to have a continued investigation into the leaks, or do you think that kind of ends with this case, with the plea?
Well, I don't, unless there's some break or something that we don't know already about who was looking at whom, or somebody either came forward and volunteered an observation about who did what when. I wouldn't think that that's going to be anything that the judge or the law enforcement people who are now speaking openly about all of these issues are going to be either excessively concerned about or particularly focused about. I think the train's out of the station on that pretty much, and I hope so. Obviously, leaking has become a part of human media interactions these days, and sometimes it's good, sometimes it's bad, but almost always it's good or bad in the eye of the beholder.
When Judge Hitler was reading the sentencing, I mean, I thought I might have caught something a little bit different when he mentioned Madison Mogen, because he said something about the word premeditated, or did he use premeditated? If you could you refresh my memory for all four of the victims, or did he use something specific into one?
Well, he would have had to say that in each of the offerings to Kohberger
Okay.
when he was assenting to the crime that he committed when he was entering his plea, because these were first degree crimes. And one of the elements of that crime in Idaho and everywhere else is a premeditated murder. So he would have used the word premeditated all four times as to those four victims in each of those four counts, 2 through 5.
The way the sentencing went down. So the original part was, I guess they can get the minimum was 10 years for every murder, and then that was the minimum. And is there a sentencing guidelines for something like that, or is this the standard? This is what you get.
Well, we don't have a matrix of so many months for such and such criminal history, such and such crime as they do in the federal system. In some of our crimes, we have just general penalties, not particularly specified. 5 years for a felony, a year for a misdemeanor, that sort of thing. And in some of our crimes, we have mandatory minimums. But in all of our felony sentencing, the judges typically sentence both a minimum fixed period during which the inmate must serve without any eligibility for parole, and then an indeterminate period on top of that in which the parole commission can consider them for release. So in this case, the judge sentenced to the mandatory without the possibility of parole as to life for each of the counts, uh, kind of overshadowing and running right past that usual procedure of indeterminate portion of the sentence. These are 4 fixed lives plus a fixed 10 years.
Does Idaho have it's like a son of Sam law like we have here in New York, or there's something similar? What is it called in Idaho?
Well, Son of Sam is kind of ancient history. You and I might remember him, as might others. But yes, we do have such a law in Idaho describing the fact that a felon cannot write a book or participate in a documentary of some kind for compensation and obtain the benefits of that compensation himself for him or his heirs or others. Instead, that money, if generated, goes to the state treasurer and is managed for the purpose of benefiting the victims of those crimes.
Good. That's another thing I don't know. I know a lot of people were concerned about stuff like that too, and I'm saying I'm pretty sure Idaho is going to have. I think every state just about has one. So yes, we're dating ourselves with Son of Sam, but anybody who doesn't know who Son of Sam is, that's your homework assignment tonight. Google
Uh,
it when we're done here. The last minute or so that I have with you, Dave, is there anything that you think the audience would be interested in or to learn about a situation like we're dealing with Bryan Kohberger here in regards to the legal system and how it played out?
Well, I'm very interested as a former prosecutor, former attorney general, public official, and defense lawyer now, working with people directly to try to obtain some appropriate result in the system from those who allegedly and actually transgressed. I'm interested in trying to understand how we get to this place in our society. It seems to me that Kohberger sent two very odd signals at points where
Oh, we might have lost Dave there. So, folks, we only had a half an hour tonight with Dave. He's very busy. Remember, there's a 2 hour time difference that we're dealing with here between the East Coast and Idaho. And I want to thank you guys for hanging out tonight. I got some new shorts that are out there about who am I. You should check them out.
there you
There
are.
you are, Dave.
I was just saying, in our society, to kind of detect and prevent these things from happening, it was intriguing to me that the studies he was pursuing were focused on the feelings of criminals during the crime, that sort of thing. And in that regard, perhaps he was trying to wrestle with his own demons as they were developing and accelerating and heading him in the direction of this thing. And so I'm hopeful that if academicians and others can somehow perceive these sorts of atypical instincts in other people, that maybe we can use the Kohberger case to say, wait a minute, let's talk a little bit more about why you want to study that, or why you want to read about that, or why you want to research about that. The other side of Kohberger, it seems to me, was an intent, perhaps, once he decided to act on those instincts, to commit the perfect crime. And here again, if somebody in our society, a friend, a police officer, a lawyer, for instance, sees somebody that's going 23 times to the same place at night between 2 a.m. and 4 a.m. in the morning, and trying to begin to build a repertoire of factual knowledge leading to the perfect crime, I hope somebody will have the ability to intercede. The situation that you just experienced in New York City with the man and the high rise and the attempted attack on the NFL. Those things just come out of the blue in our society. But in the case of Kohberger, we had some kinds of signals over considerable periods of time when people ought to or might have observed if they were a little more sensitive to the the Kohberger profile. And maybe he's done us a favor there if we can somehow prevent the next situation from happening in Idaho or any of the other 49 states. He's taught us some lessons, and I'm glad we're able to teach him a lesson.
Yes, and especially with the police department, right? Nearly hired him to bring him in there. Talk about putting
Yeah,
the wolf in the hen house. So yeah, there's a lot of lessons to be learned there. Dave, thank you very much. This was fascinating, and I think I myself and the audience has learned a lot. And we appreciate your time here. We
you're
know
welcome,
it's very
Sarge.
valuable, and you're very busy.
Carry,
Thank you very much, and we'll
carry
talk
on, Sarge.
soon. Take care. Thank you. Have a great night.